Hello everyone, welcome you all to the course on corporate law and governance. In this video, we are going to learn about the incorporation of companies. Before we learn about the steps that are involved in incorporating a company, we need to know about the promoter of a company. A promoter is the one who actually conceived the idea of starting the business, who has taken all the steps in incorporating the company, who puts in efforts in bringing together the different people like the chartered accountants, banker, solicitor, etc. in order to start the business. If we look at the definition of the promoter of a company, we can understand that anyone who has been named as the promoter in the prospectus of the company is considered as the promoter of the company. The promoter would have control over the affairs of the company. It could be directly or it could be through indirect means, by acting as the member, director or otherwise. And promoter is the one to whom the board of directors would look up to, whose advice would be taken into consideration in order to take any decisions for the company. Now we are going to look at the duties, rights and liabilities of the promoter. The first duty of the promoter is not to hide any profit that they make in the operations of the company. They have to disclose all the hidden profits. So it doesn't mean that the promoter should not work towards making profit for the company. Only thing, it should not be hidden and it should be disclosed to all the stakeholders of the company. The next duty of the promoter is to disclose all the material facts. The reason being, the promoter holds a fiduciary relationship with the company and its stakeholders. It is the relationship of trust. So it is mandatory for the promoter to disclose any material facts pertaining to the operation of the company. The next duty of the promoter is to act in the best interest of the company. That means the promoter should always put the company's interest ahead of their personal interest. Whatever actions that the promoter takes, it should be favorable and it should be in the best interest of the company. Next, let's look at the rights of a promoter. The first right of the promoter is the right of indemnity. Whenever the promoter makes any hidden profit, or whenever the promoter gets into any kind of fraudulent activities, they are liable for their actions and they have to bear any financial liability that arise out of it. And we all know that there would be more than one promoter for a company. So if a promoter is paying for the damages that had been caused by the promoters, the promoter who has paid for the damages has the right to claim the share from the rest of the promoters who are equally liable. So if we look at the liability of the promoter is several as well as it is equal. Next right of the promoter is to get back all the preliminary expenses that the promoter has incurred in forming the company. In order to form the company, the promoter would be making different types of expenses like the advertising expenses, solicitor fee, so on and so forth. All these preliminary expenses should be paid back to the promoter. The promoter has the right to get back these preliminary expenses from the company. The next right of the promoter is the right of remuneration. Every promoter has the right to get the remuneration from the company for their contribution to the company, unless and otherwise there is a contract contrary to this. And the promoter cannot sue the company for not getting the remuneration if there is no contract that says that the company should pay remuneration to the promoter. Next, let us look at the liabilities of a promoter. The first liability arises whenever the promoter makes any secret or hidden profit. The promoter has the liability to pay back any hidden profit he or she makes during the operation of the company. They are also liable for any kind of false statements that they make in the company prospectus. Because of the false statements, if the subscriber to the bond or the stock suffer any kind of damages, it is the liability of the promoter to pay back the damages that has been caused to the bondholders and the stockholders due to the false information that was provided in the prospectus. The promoter is also liable for any kind of fraudulent activity that he or she involved in the formation of the company. Next, let's look at the preliminary or the pre-incorporation contracts. Normally, before the company gets started, the promoter would be entering into different types of contracts with the outsiders in order to form the company or during the process of forming the company. So, whenever these kinds of contracts are made, are they legally binding on the company? That is what we are going to look at. We can see that since the company itself is not being formed, because the company is non-existent, because it is the pre-incorporation period, it is yet to be incorporated. So, the company does not exist at all. When the company does not exist, that means the company is not bound upon the contract, but the promoter who actually enters into the contract would become personally liable for the performance of the contract. Let us look at two cases in order to get more clarity on these preliminary or pre-incorporation contracts. Let's look at the case of Kellner versus Baxter. Kellner entered into a contract with Baxter before the company was formed. He entered into a contract for the formation of the company. In the particular contract, the contract was signed by Kellner. It was written like he is signing for and on behalf of the company. Kellner failed to perform the contract. Baxter went to the court, but the court told that the company cannot be made liable for the non-performance of the contract, because at the time of the contract the company was non-existent. But since Kellner has made the signature that for and on behalf of the company, Kellner is personally liable for the performance of the contract, but the company cannot be made liable for the non-performance. Next, let's look at the case of Leplot Newborn London Limited versus Sensolid GB Limited. Here, Leplord Newborn London Limited entered into a contract with Sensolid Limited for the supply of certain goods to Sensolid, and this contract was made before the incorporation of Leplord Newborn London Limited, and Sensolid knew that Leplord Newborn London Private Limited was non-existent at the time of the contract, and in the due course the company failed to perform the contract, and Sensolid went to the court. But here the judgment was that the whatever liability that had been expected from Leplord Newborn is null and void, because Sensolid also knew that the company was non-existent at the time of its at the time of the contract, and both the promoter as well as the company is not liable to perform the contract, as Sensolid knew that the company was non-existent at that time. Next, let's look at what are all the procedures for the registration or the incorporation of the company. Before we get into the steps, we should know that Section 3 of the Companies Act of 2013 looks at what are all the minimum requirements to start a company. According to Section 3 of the Companies Act, as we all know that a private company should have a minimum of 2 members, and it should have the maximum of 200 numbers. A public company should have a minimum of 7 members, and the maximum is unlimited. If it is going to be one person company, there should be only one person to form the company. And Section 7 of the Companies Act 2013 looks at the procedures or the steps that are involved in the formation of the company. Let's look at each of the steps one by one. The first step that is to be done is the filing of the documents and information with the registrar by the company. The company should prepare the memorandum of association, the article of association, and it should be duly signed by all the subscribers to the memorandum of association, as well as by the directors whose name had been mentioned in the article of association, and the signature should also, or declaration should be made by the chartered accountants, the solicitors and the bankers, stating that they have complied with all the rules and regulations which they are supposed to follow while preparing all these documents, like the memorandum of association and the article of association. A declaration should be made by the subscribers to the memorandum of association, as well as the directors whose name had been mentioned in the article of association, stating that they were not involved in any kind of fraudulent activity in forming a company, any company for that matter, in the past 5 years, and they never violated any kind of rules while forming any company. And they should also make a declaration that whatever information that had been provided in the memorandum of association and the article of association, that is that they have given all the information which they think that it is true to their knowledge and belief. And the company should also give the mailing address which would be used until the company comes with a registered office. And the other particulars, like the particulars of the subscriber to the memorandum of association, the directors whose name had been mentioned in the article of association, should be given, like their name, address, with the necessary proof of identity. And these information should be given, which should be filed with the registrar. Once all these documents and informations are filed with the registrar would be checking the validity and the truthfulness of all these information, and once the registrar is satisfied with the information that had been provided, the registrar would be issuing a certificate of incorporation to the company. And once in the certificate of incorporation, they would also mention a corporate identity number. So, every company would be allotted a corporate identity number. This corporate identity number is a unique number which is distinct for a particular company. It is the duty of each company to maintain all the copies of all the documents and the information which they had provided to the registrar of companies in the register office until the company gets owned up. Next, let us look at what are all the actions that the tribunal would take in case the company comes with the incorrect information, or if it furnishes the false information. Section 447 deals with the actions that would be taken on the company when they furnish any false or incorrect information while incorporating the company. The tribunal may order to change the contents of the memorandum of association and the article of association in order to protect the public interest or to protect the interest of the members or the shareholders or the creditors of the company. They may order to change the liability of the members. They may change the liability from the limited liability to unlimited liability. Sometimes they may order the removal of the company name in the register, and at the extreme step they may ask the company to wind up its operation. Though these kind of orders would be passed when the company furnishes the false information, the company would be given enough time to defend themselves. In this case, only after proper scrutiny, these kinds of action would be taken by the tribunal. Now, we are going to look at the simplified pro forma for incorporating company electronically. Nowadays, it has become mandatory for the companies to incorporate their companies through online mode, which we call it as SPIC-E, that is simplified pro forma for incorporating company electronically. This memorandum of association, article of association, all these would be submitted in the electronic form only. And if we look at the portal that we have in the Ministry of Company Affairs, all the services are done only through online mode, like the giving the director's identity number, or reserving the name of the company, incorporating the company, providing the permanent account number, which we call it as PAN, and also providing the tax deduction and collection account number. All these services are provided online through the portal or in the Ministry of Company Affairs. Let us see what are all the prominent features of this SPIC-E. If you look at it, the company can reserve the name of their company in the portal itself, and the subscribers to the memorandum of association, the directors, witness, all should have the digital signature certificate. And memorandum of association and the article of association are in the standardized form, and all have to follow the standardized form that had been given in the portal. And not only that, the promoters and the directors can track the documents that had been uploaded, and if anyone had done any changes in the document, all these can be tracked online. If the promoters and the directors are going to find it difficult. While doing it online, there is a dedicated email and helpline facilities available, wherein whatever the issues that the directors would face while incorporating the company online would be resolved through these dedicated email and helplines. Next, let's look at how the company gets registered online through SPIC-E. The first step is all the subscribers to the memorandum of association, the directors, the witness, all have to have the digital signature certificate. No ink signature is allowed. All have to get these digital signature certificate. We do have the government certified issuing authorities of this digital signature certificate, and this can be got online within 2 days of the application. And the subscribers to the memorandum of association and the directors, promoters and the witness should have class 3 category of digital signature certificate. And once they log in to the portal, the directors supposed to have the identification number, and director identification number can also be applied through the same portal. And the Ministry of Company Affairs give the director identification number to the maximum 3 directors. In case a company is going to have more than 3 directors, what they have to do is, after the company gets incorporated, they can apply for the director identification number for the rest of the directors by filling the form DIR 3. So once they register themselves, once the company register themselves in the MCA portal by getting the digital signature certificate as well as the director identification number, they have to fill in the EMOA and the EAOA, and there are 2 parts in this SPIC-E plus. One is part A and another is part B. In part A, the company first should get approval for the name of the company, because the company name cannot be the same as that of an existing company. It cannot be a controversial one which is not allowed by the registrar of companies. So first thing is, in part A, the company should apply for registering the company name, and in case the company name gets rejected, they have to again apply for it by paying the required fee. Once the company name gets approved, within 20 days of the approval of the company name, the company should finish filling the part B. In part B, we talk about the EMOA and the EAOA, that is the Memorandum of Association and the Article of Association. In the electronic form, it should be filled and it should be uploaded. Once the company uploads all the relevant documents, it would be scrutinized by the registrar of companies, and based on the complying all the necessary requirements, the certificate of incorporation would be issued to the company. These are all the procedures that should be followed in order to register the company in the online mode. Once the certificate of incorporation is being issued, we call that as the company has been registered. The moment that has been given, all the members of the company become the body corporate, and we all know the company is a separate legal entity which is distinct from its member. The company can enter into contract with the members, with the outsiders. The company can sue others. The company can be sued, they can lend money to others, they can borrow money, because company is distinct and separate from its member, and the company will keep on existing, which we call it as perpetual succession. The company will keep on existing even though the shareholding pattern changes, even though the members die, and even though there are going to be changes in the structure of the company will keep on existing unless and until it is being closed through lawful means. And the company is an artificial legal person. It cannot operate on its own. It needs someone, since it is artificial in nature, and the directors would be operating on behalf of the company. Let's look at some of the case laws that we have with respect to the effects of registration. In the case of State Trading Corporation India versus the Commercial Tax Officer, here the State Trading Corporation India was asking for the citizenship for the company. When we say citizenship, they want to, can a company be considered as a citizen of the country, wherein do they have the fundamental rights. But it was the judgment clearly told that though we talk about the nationality of the company, in order to distinguish the nationality of one company from another company, but that doesn't mean that the company can become a citizen and can claim the fundamental rights just like a natural person, because though it has a separate legal entity, a company is an artificial entity as such, and it may have nationality, but a company cannot claim citizenship and ask for the fundamental rights like any other human being. In the case of Heavy Electrical Union versus State of Bihar, the judgment was that, like, though this Heavy Electrical Union is run by the central government, it doesn't mean that Heavy Electrical Union can be considered as the agent of the central government. Though it is a government company, still the company is distinct from its members, and it has a separate legal identity like any other private and public limited companies. In the last case, we have the case between Mrs. Bacha F. Guzdar with the Commissioner of Income Tax. Mrs. Bacha F. Guzdar was having a tea estate, and the income that was generated from the tea estate was exempted from the taxes, and the company was getting concession in the taxation as it fell under the agricultural income. Mrs. Guzdar was getting dividend from the company as she is one of the members of the company, and she was asking for exemption for the dividend which she has been getting from the profit of the company. But the judgment clearly told was like though the company is run by Mrs. Bacha F. Guzdar, it doesn't mean that she is part of the company and can claim the tax concession, because the company is distinct from the members, and whatever concession that the company has cannot be claimed by the members. Thanks for listening.